Brad Weber.
How do you spell Brad?
BRAD.
And Weber?
WEBR.
When we last were talking, you kind of got upset with me. Do you remember why you were upset?
Yes.
Why were you upset?
I was upset because you were trying to tell me what I did.
And particularly what?
What I did when I got off work.
Okay. And you testified on the stand that you went directly home from work, is that correct?
That's correct.
That's not what you told Agent Pohl and Christopher Goatee when you met with them on February 19, 2017.
Okay. Who are those guys?
Law enforcement officers.
Okay.
Do you remember meeting with law enforcement officers?
Multiple times.
Okay. I'm gonna hand you one of their reports and ask you to read the second part. You can read all of it, it's not very long, read the second paragraph. Tell me when you're done.
I'm done.
You told these officers after you got off that you went to your various ATM machines that you own and performed routine service, is that what you told them?
I don't recall that.
Okay. But that's what that says.
Judge.
That's what this says.
Judge, I object. That's improper impeachment. He's given it to him. He says he doesn't recall that. That's the end of the impeachment, Judge.
Sustained.
The week before February 13, 2017, where were you?
I don't know.
Do you remember being in Arizona and visiting your folks?
Not a week before. I went on a 3-day trip to Arizona.
Okay.
Not a week.
Okay. That's fair, that's fair. And you got back when?
Sunday.
Okay. How often in 2017? Well, strike that. We need to talk about your ATM business. Tell the jury about your ATM business.
I have ATMs.
Well, what are ATMs?
Money machines.
All right. What does it stand for, if you know?
I don't know.
Okay. And back, what do you do? I mean, do you use these machines to make money?
Yes.
How do you make money with the ATM machines?
Surcharge.
Okay. Tell the jury a little bit about that surcharge.
When someone takes money out, they get charged a surcharge.
And so you.
I get the surcharge.
You get the surcharge. And.
After I pay the people that own the business.
So we see these where we push a button and there's a, are you willing to?
Yes.
All right. And how many of those machines, back in 2017, did you have?
I don't know.
Would it help refresh your recollection by looking at the deposition?
I guess. At one time, I had 30-something, and this day, I have maybe 15.
Okay.
Does that help?
It kind of does, but I really need you to kind of bear down on 2017. If you would look at page 6, lines 5 through 7. How many, I'm sorry, are you done?
Yeah.
How many, back in 2017, did you have?
I don't know. This says a estimate.
Okay.
Do you want an estimate?
Sure.
35.
Okay. Thank you. So, and how often, in 2017, would you be attending to your 35, roughly, ATM machines?
I don't know an answer to that. It's on a need basis. If they start to run out of money, I will put money in it.
Would it help refresh your recollection by looking at your deposition?
Sure.
Page 8, lines 5 through 7. Does that refresh your recollection?
I don't, okay. I guess I don't remember the question.
How often would you be attending to your ATM machines in 2017?
I do something with ATMs every day.
Okay. What would you do every day with these ATM machines? What kind of maintenance do they require, if any?
No maintenance. I look upon the computer to see where they sit money-wise.
Okay.
So that, I can sit at home and look on the computer and tell where they're at.
Okay. You got to go to, how do the money machines get money in them? Who puts the money in there?
Me.
How does the money machine get the receipt tape in there?
I put it in.
Okay. How does the money machine get money taken out of it?
I don't know.
Are you, oh. Where do you get the money from?
I get the money from the bank.
Okay. So you.
I don't take money out of the ATM machine, I put money in it.
Good to know.
A customer takes it out and pays a surcharge.
Okay. And then who, the surcharge goes directly to the bank?
It goes to the network.
All right. So what happens when the money runs out, the McKinney runs out of money, what happens?
It has a screen that doesn't let it go, doesn't let it dispense any more money.
Are you making money when the machine runs out of money?
No.
What about the receipt, when there's no receipt?
That don't bother me.
Okay.
I mean, yes, I put the receipt paper in there. When the machine gets low on money, I go to the bank and get money and I take it to the machine.
Where do you go to the bank? What bank did you go to back in 2017?
Oh, I really don't know. I'm guessing, if I had to guess, I would guess Regents, but I'm not sure.
Okay. And so you would you have to give them like a check or how would you get the money out?
Okay. So you take money out of a ATM, $100.
Affirmative response.
It takes that money out of your account, along with a surcharge, and puts it in my account.
I'm talking about the cash that you put in there.
I get it from the bank.
Okay. And you have to maintain those machines by putting cash in there on a regular, the 35 machines from 2017, correct?
Yes.
And what kind of places were these ATM machines? Like were they in banks? I'm gonna guess not, but I could be wrong. Where were they?
Gas stations.
Gas stations.
Taverns, restaurants.
What geographic area were these 35 machines in 2017? Where were they?
In Indiana.
Okay. Give the jury an idea of where though in Indiana.
From.
Judge, I'm gonna object T at this point. I don't know how this is relevant. I don't know how this line of questioning is relevant, Judge.
How's this relevant?
Trying to establish that he has to maintain his 35 machines, including on the day in question, February the 13th, 2017.
Well, could we narrow it to that date, then, cause this is really not relevant.
I'm starting with the broad scope and then I move down into that.
Okay. Well, then let's move down into that.
What would necessitate the need to attend to any of your 35 machines, ATM machines, in 2017?
Lack of money or lack of paper.
And you had been out of town for at least 3 days prior to this, is that?
That's correct.
Okay. Would you use your van to service ATMs?
Usually not.
You used your blue Subaru.
I don't have a blue Subaru.
What did you have back in 2017?
I had a black Subaru.
Black Subaru, okay. Just so the jury understands, where in 2017, in February of 2017, where were the, I think, because I don't think this question had been answered, where were the ATMs geographically in February of 2017?
Central Indiana.
Okay. How close were they to the bank that you were using in February of 2017?
Judge, I'll object again. I don't know how this is relevant.
Overruled.
Where, I used multiple banks.
Okay. Now you used multiple banks.
Regents, but I don't always go to the same branch.
Okay.
If that's what you're talking about.
So if the bank was closer to one of these 35 ATM machines back in February of 2017, you would go to that bank closest to the machine, the place where you were going to work on the machine or fill it with cash.
No.
Okay. Then what?
I would have to call the bank and order the money.
Okay.
So it wasn't always the same branch. It's usually branches in Lafayette, if that helps.
All right. Did law enforcement ever ask you about, let's say Goatee and Pole that you talked to, did they ever ask you, hey, can we see your phone records about what banks, if any, that you called to order up this cash? Did they ever ask you that?
I don't remember.
Did you tell Pole and Goatee that you went?
I don't remember. I don't even know who they are. I mean, I talked to.
But.
A lot of people.
But your memory today is, after, that you went straight from work to your house, is that correct?
I went on the day in question, when I got off work, I went straight home.
And you normally work till 2:30, correct?
If I'm on day shift, yes.
And on that day, you got off at 2:02 p.m.
That's correct.
Now, was that to service your ATM machines?
No. Subaru's not gonna let me off any time special because of my side business.
Well, they let you off special that day, 2:02.
They chose for me to leave, not me.
So you had a phone call with somebody in August of this year, asking you to come to the police station, is that correct?
No.
That's not correct.
No.
So nobody from the law enforcement called you and said, hey, we want to talk to you.
They did say that.
They did?
Yeah.
What were you saying no to?
You asked if they asked me to come to the police station, and they didn't.
Well, what did they ask you?
They asked me to come to a different location.
Okay. That's fair. And then, after that phone call, you then told them, and who was the person that called you, if you remember?
I don't remember. You should have it.
Yeah. You remember Steve Mullen?
It could be him. I've talked to him on the phone, yeah.
Was it him or not? I can find it in your deposition.
I don't know. I don't remember.
Okay. Would it help refresh your recollection?
It could have been him.
Okay.
Sometimes I got texts.
Page 18, is it okay to refresh your recollection?
Isotoptome? I don't know what you're asking.
You know, that's a valid question. I'm asking you, would you mind refreshing your?
Yeah.
And again, it's page 18, lines 25, the very bottom of page 18, the top of page 19. The bottom of page 18, top of page 19.
Okay.
So the question was, who called you to come in and talk to them from the law enforcement?
It says, probably Steve. I don't really remember. It was either text or call.
But whoever it was, you said Steve.
It says, probably Steve, right?
Okay. Is that Investigator Mullen?
Probably.
Okay. But you called him Steve.
I don't know. That's what they typed up. I don't, where's that from?
Remember when we had the deposition?
When you subpoenaed me?
Yes.
Yes.
Okay. So did you call the guy you met with Steve?
I don't talk to him. I mean, that's his name. I don't know.
After that phone call with Steve, you came in and told them that you drove directly from work in a van, is that correct?
Judge, objection. It's a leading question.
Sustained.
What did you tell? Thank you. What did you tell?
That on that day, I drove a van to work, dropped off a trailer. When I got off work, I drove home.
Is that different than you told any other law enforcement in the past?
I don't know.
Okay.
Not to my knowledge.
What vehicles did you have back then and when would you use them back in 2017?
To my knowledge, I just had the Subaru and the van, and the only time I used the van was when I was pulling a trailer.
So 9 out of 10 times, you'd be using the Subaru.
Yes. More than that.
Did you first tell law enforcement that you drove the Subaru on February 13th?
I believe so, but I don't remember. Normally, I drive the Subaru.
Was your memory better in 2017 than it is now?
I'm getting older, I guess. I don't know.
How long? What did you do when you got home from work that day?
Took a nap.
Okay. Do you know how long?
Nope. Until I got woke up.
Did you go right to sleep when you got home or did you wind down first?
Probably smoked a cigarette and relaxed a little bit, but pretty much went straight to sleep.
What time did you wake up, if you know?
I believe it was around 5.
How did you wake up?
Someone knocked at the door.
What did you do after the officer was there?
Went back to sleep.
What was that conversation with the officer?
He informed me that they were looking for a couple missing girls and that, asked about the bridge.
You're familiar with that, where the Deer Creek is, correct?
Yes.
And your house is kind of up here and the creek is down here, is that fair to say?
Yes.
And you're on the south side of the creek, is that correct?
Yes.
Have you ever been on the north side of the creek, on that property north of the creek?
Yeah. I am right now.
What do you mean?
I'm on the north side of the creek right now, right? Or am I in the south?
I think you're on the south side.
Okay.
The opposite side of where you are, have you ever been on that side of it?
Yes.
Do trespassers come onto your property?
Yes.
Did they back in 2017?
Yes.
Would you ever confront those trespassers about getting?
Yes.
Would you have been able to hear, from your house, if anybody was screaming?
Judge, I'm gonna object to speculation.
Sustained.
It would depend if I was inside or outside. Yes, if I was outside, I could.
You did not hear any screaming on February 13th when you got home, did you?
I didn't.
Now, if you got home at 3:30, well, strike that. You heard no screaming on February 14th, did you?
Objection.
No.
Oh, sorry, Judge.
Who had access to your parents' property in 2017?
Me.
And what about your brother?
Like, it's land, I don't know what you consider access.
Who visited the house at your parents' property in 2017?
I can't list all the people that visited, I don't know how to answer that.
Well, and that wasn't.
A whole year time? You want to know all the people that came to my house?
No, that's fine. I do think we need to clear up one thing, that's not your property, correct?
That's correct.
How many houses did you own back in 2017?
I think one, but I don't know.
Okay. You had a house in Lafayette then?
I believe it would be in between Rossville and Delphi.
Okay. Did you live in a trailer, as well, at some point in time in 2017?
Yes. I don't know.
Okay.
I believe so.
If you were driving on that lane, I'll call it a lane, the driveway off of 625 past the Liebert house, can I call that a driveway?
Sure.
Is that fine? And you're looking to your left, would you, in February of?
If I was looking that way, I probably would have.
When was the last time you were on the other side of the creek, the north side of the creek?
This summer.
How many outbuildings are at your property?
5 maybe.
Okay. How many stories is your house, 1 or 2 stories?
2.
2 stories. Did you give law enforcement permission to go into your outbuildings?
Yes.
I'm gonna ask you to refresh your recollection, if that's okay, page 85, lines 4 through 5, page 85, lines 4 through 5.
Judge, again, what are we impeaching here?
Do not know.
I'm not impeaching, refresh. I asked if it would refresh his recollection about did he give law enforcement permission to go into the outbuildings.
He answered the question, Judge. There's no need to refresh his recollection.
Okay. Go ahead.
Okay. Did you give permission to?
Judge.
Yes.
Hold on, sir. Go ahead.
All right. So today you're. Do you want me to go ahead?
Well, is that correct?
I'm gonna now impeach Hyam. That is not correct according to his deposition.
Are you saying on the 13th? And before you said did I give law enforcement? Yes, I did. They searched my house. It wasn't on the 13th.
Okay.
But yes, I did give them.
Do you want, I don't want to overstep. Am I good to go or?
Well, I don't know where you're going. He's answered your question.
Yeah. On the 13th, did you give law enforcement permission to go into your outbuildings?
No.
That's what I wanted. Thank you. Where did you park your vehicles back in February of 2017?
I don't know. I believe the van was in the grass and I believe the Subaru was in the driveway.
Okay. I'm gonna hand you a photograph that was I think taken in.
That looks like my garage, yes.
Okay. Is that what it fairly and accurately looked like back in February of 2017?
Yeah.
What is the vehicle there parked in the car, in the garage?
Judge, I'm gonna object at this point. Can I see what he's showing him? Is there a date stamp on it, showing what date it's from?
Do you know what vehicle that is in the garage?
Well, hold on a minute, Judge.
I don't.
Hold on.
I object to this line of questioning, 1 for relevance. 2, Judge, he hasn't established when this picture was taken or who even took it.
He says that it fairly and accurately depicted what his garage looked in February of 2017.
He didn't say February 2017. What I heard was 2017.
No, I said February.
Okay.
I move to admit KKK.
State's gonna object to relevance, Judge. I don't understand the relevance of this line of questioning.
How's this relevant?
There's sticks on the ground or the floor there of the garage.
I cannot rule on an objection, and I don't have the proper information. Okay. So the objection is relevance. And when was this photograph taken?
According to our, February 19th, 2017.
Okay. So I'll show this is on February 19th of 2017.
Yeah.
Okay. I'm not sure how it's relevant, but I'll admit it over the state's objection. Defendant's Exhibit KKK admitted.
Move to publish.
You may. Defendant's Exhibit KKK published.
Judge, while that's being published, could we have a sidebar, please?
Yes.
Sidebar conference conducted.
Inaudible, used to he hasn't established any third party, and so that may be a danger now if he asks any more questions about the sticks and what he does with the sticks, but it's inaudible.
He said that he didn't give permission to use his outbuildings or for the police to go in there. I don't have to accuse him, I don't have to accuse him of it, I can say somebody walked in there and dropped sticks. It could be them together. By the way, Judge, he had a gun that was not excluded. He lives right across the way. He's told different stories about his direct route home.
So he's inaudible?
Well, I think I have the right to do it.
If you can meet the nexus.
Well, and also anybody that was in the area could have used his outbuilding to hide the girls until and.
It's the state's opinion that was inaudible.
We're not doing that.
Not doing what?
We're not going any further with this line of questioning.
Okay. That's fine.
Sidebar conference concluded.
I just wanted to clarify that, when I asked you about the outbuildings, you said there were 5, and the number of stories on the house, and you said there were 2, we're talking about the property off of Deer Creek there, correct?
I believe so, yeah.
Okay. I just didn't want the jury confused that it was somebody else's, your property in Lafayette there.
Oh. Okay. So I guess there would be 3 in 17. There's 5 now.
Oh, okay. Thank you for clarifying. 3 outbuildings in 2017.
I believe so.
All right. No other questions. Thank you.
May I have the exhibit, please? The court reporter, thank you. Mr. McClelland.
Thank you, Judge. Mr. Weber, good afternoon. There was a question by Mr. Baldwin about your memory being better in 2017, and generally, would you agree that your memory would be better in 2017, or closer to February 13th, 2017, about what happened on that day?
I would agree with that.
Okay. And you testified to this, but you talked to law enforcement several times. Is that correct?
That's correct.
Do you recall talking to law enforcement on February 17th of 2017, just a few days after the girls went missing?
I don't know the date, but they stopped me coming home a few times.
Sure. Do you remember talking to you probably don't remember the officers' names, but do you remember talking to an officer Shane Burhart and Indiana State Trooper Brian Kubiak?
I don't know. I got stopped on 625 and they searched my car and searched my house and talked to me and gave me a lie detector,
Let's back up a little bit. On February 13th, 2017, you were at home taking a nap and a police officer woke you up. Is that right?
That's correct.
And he asked you to look around your property. Is that correct?
He asked if he could.
If he could look around your property?
Yes.
And you told him, sure, go ahead.
Yep.
At that point, did he ask you to look in any of your outbuildings?
No.
Okay. Later on, law enforcement did ask you to look in your outbuildings. Is that correct?
Yes.
And you did let them do that?
Yes.
You let them search your house, even?
Yes.
After you were awakened or woke up by the officer on the 13th at 5:30, do you remember the very next time you spoke to law enforcement?
At 8.
Okay.
Around 8.
Did you ever talk to law enforcement on February 17th, a few days later?
I talked to them every day for quite a while.
If I were to show you a police report from February 17th of 2017, would that help you remember whether or not you talked to law enforcement on that day?
If it's the day that I'm thinking, it's when they stopped my car going home. I believe that was the 17th, but I'm not sure.
If I showed you this document, would it help?
Maybe.
Okay. I want to draw your attention to the date on there. Do you see the date?
Yes.
Okay. And then I want to draw your attention, so let me start here. Do you remember talking to law enforcement this day?
I remember talking to them. I don't remember this particular guy.
Okay. That's okay. And when you talked to law enforcement that day, you told them that you got off work at 2:02 p.m. Is that correct?
That's correct.
And you told them you went straight home. Is that right?
That's correct.
And that you got home right around 2:30. Is that correct?
That's correct.
And that you were awakened at around 5:30 by a sheriff's deputy. Is that right?
That's correct.
Again, this is on February 17th of 2017, correct?
Yes.
Okay. Now, when I want to fast forward to 2024, when you got a phone call or a text to come back in and talk to law enforcement, you said you didn't remember if it was a phone call or a text.
That's correct.
Okay. Would it be common in the area where you live to not receive phone calls?
It's, or lose them or drop them.
And so is it common for people to text you?
That's correct.
Because texts come through better than phone calls?
Yeah. Yes.
Okay. And during that text or phone call, did the officer that contacted you, did they tell you what they wanted to talk to you about?
No.
They just said, "Come into the building. We'd like to talk to you, ask you a few questions."
Yes.
Okay. I don't have any other questions, Judge. Thank you.
Mr. Baldwin.
But you told Officer Goatee and Robert Pohl something different, didn't you, about your...
I believe a lot of I believe so, according to you.
Okay. Thank you. No other questions.
Mr. McClelland.
I don't have any other questions, Judge. Thank you.
Does anybody on the jury have any questions for Mr. Weber? Would counsel approach?
Sidebar conference conducted.
How far in advance do you have to order C-Ash for the ATMs?
Fine, yeah.
Yeah,
What is the process for you to clock out of work?
I'm fine with it.
That's good.
The report indicates E-exit RD02. What does that mean?
I don't know what report they're talking about.
I didn't know. I'm gonna object. We don't know what report.
Okay. What driveway do you use to access your home?
That's fine.
Do you drive under the High Bridge, and did you use that route on February 13th, 2017?
Good question.
Do you know if the ATMs were photo or video of? Do you know if the ATMs with a photo or video of when you would be servicing them?
Yep.
I don't know, Judge. There's something about that question. I don't think it's relevant.
If he knows.
I mean, we're getting into the weeds here. This is not even close to relevant.
Hold on. I'm sorry, Judge, with respect, I mean, they're trying to figure out whether or not he was working on his ATM machines and if there's a camera that could prove that he did or didn't, so I think it's relevant for sure.
Okay. So if they ask if there's a camera, we don't have that because nobody got that.
He'll either know or he won't know.
So I'll ask that over the state's objection. On February 13th, 2017, would you have went home after work to map out what machines needed filled after inaudible? Because he said he went home and went to bed.
Yeah,
I don't care one way or the other.
inaudible.
We're just marching down a path of.
That's fine.
Do you typically go home after work at Subaru before servicing your ATM?
That's good.
Okay.
Sidebar conference concluded.
Mr. Weber, do you know if the ATMs would have photo or video of when you would be servicing them?
The ATM itself wouldn't, but some of the locations did.
Okay. Any follow-up, Mr. Baldwin?
No, Judge. Thank you.
Mr. McClelland?
No, Your Honor.
How far in advance do you have to order cash for your ATMs?
Okay. So the problem's not getting cash, it's getting 20s, cause the ATMs I have, all they have is 20s, all they dealt with. And at Regents, it's usually a week, order it a week out.
A week. Okay. Mr. Baldwin, any follow-up?
No, Your Honor. Thank you.
Mr. McClelland?
No, Your Honor.
What is the process for you to clock out of work?
When you go through the turnstiles, you use a badge and that's what clocks you in and out.
Your badge, okay.
Yeah.
Mr. Baldwin, any follow-up?
None, Your Honor. Thank you.
Mr. McClelland.
Yes, Judge, just briefly. So, Mr. Weber, just as you're leaving, you flash your badge at the turnstile and you walk out?
It releases the turnstile to allow you out.
Okay. Thank you, Judge. Nothing else.
What driveway do you use to access your home?
The driveway right by Liebert's, the driveway that goes underneath Monon High Bridge.
Mr. Baldwin.
So you never use your other driveway? Well, isn't there another way in and out of your...
Yes, there's another way. I could get in and out without using the driveway.
Okay. And do you do that sometimes?
I have, yes.
Okay. No other. Thank you.
Mr. McClelland.
No, Judge.
Do you drive under the High Bridge, and would you have taken that route on February 13th of 2017?
I would have and yes.
Mr. Baldwin.
No questions.
Mr. McClelland.
No, Your Honor. Thank you.
And do you typically go home after work at Subaru before servicing your ATMs?
Typically, I don't, no.
Okay. Mr. Baldwin.
No questions.
Mr. McClelland.
No, Your Honor.
All right. Thank you, Mr. Weber. You may step down. And it is my understanding that the defendant has no further witnesses for today.
That is correct, Judge.
Well, all right. Well, ladies and gentlemen, while you go on about your own business the rest of the afternoon and the evening, please, remember what I've told you about not talking about the case amongst yourselves, or with others, as you will be in the company of the bailiffs. Just go ahead and leave all your materials there and Jody will collect those, and have those available for you. Please have a safe and a peaceful evening. Gentlemen.
All rise.
Jury out at 3:31 p.m.
All right. You may be seated. My understanding, Mr. Baldwin, is that you wish to make an offer of proof.
Oh, thank you, yes. We had intended to call Kevin Murphy, who you said to be a state trooper, worked on a case from 2017, all the way up to I believe it was 2021. Should he have testified, he would have said that the entirety of his time working on the investigation of this case, when he would listen to UNIFID Command's kind of daily updates, that they always said that there was 2 to 3 people that the Unified Command believed were involved in the commission of the crimes, possibly as many as 5 to 6, and that was consistent. And what was never stated was that there was only one person involved. And Kevin Murphy, who was here earlier, had he been able to testify, that's what he would have talked about, Judge.
And I believe the state objected to Mr. Murphy's testimony.
Yes, Your Honor.
Did you want to?
Oh, Judge, just.
Get your objection on the record.
We've heard other testimony about what Unified Command thought prior to the arrest of Mr. Allen. I don't know that Mr. Murphy was in a place to even testify. He wasn't part of Unified Command. He didn't have daily contact with them. I don't think that I thought his testimony was gonna be speculation, at best. And again, we've already heard from other officers what Unified Command thought prior to that, so the state objected to him testifying.
Is there anything additional on your offer of proof?
Just ask. I think this has really been done. We would ask that Mr. Murphy's prior testimony at the August 1st hearing, or, I think it was August 1st, the series of hearings on July 30th, 31, and August 1st be incorporated into our offer of proof.
Okay. All right. And I did sustain the state's objection on cumulative, as there is evidence in the record that supports what you are arguing. Is there anything else from the defense?
Judge, since we're ending early, I have an offer of proof that I could work with Mr. Holman as it relates to certain questions. It won't take very long, 5 to 10 minutes I think.
Okay. And
I can have a sidebar, if you want to talk about it, but...
I'm sorry, I don't know what the nature of your offer of proof.
It's related to the third-party suspect. It's a new M about to ask for the record for the Court of Appeals.
Okay. So all right. Does the state have I'm not sure exactly what we're talking about here.
I'll tell you what the questions are and then you can tell me. If Richard Allen had told police that, had asked law enforcement, if my spit is found on one of the girls, but I have a good reason for it, would that evidence be used in this trial? And then a series of those types of questions.
If the defendant told Mr. Holman that.
That's what I would be asking Lieutenant Holman, it could be Investigator Mullen, either way, a series of questions along those lines, whether the things that I attribute to Brad Holder and Elvis Fields, were those things to be found in Richard Allen's social media or statements made, would they, law enforcement, have used those pieces of evidence in a trial, the series of questions would be along those lines.
Okay.
Judge, what he's doing is using the evidence that he believes is evidence against Elvis Fields, and he's implying that to Richard Allen, then asking the officer would that be used in trial. That calls for complete speculation. If it was just that evidence alone that we had against Richard Allen, he wouldn't even be charged. That's why Elvis Field, is not charged. That is not enough evidence to tie anyone to the crime. Would it be used in conjunction with the other evidence against Richard Allen? That's complete speculation, and that would be at the prosecutor's discretion of what evidence to use at trial, not Holman.
Another question, just for the record, that would be asked is if there were a faked crime scene photo in Richard Allen's computer or on his Facebook page that showed 2 young girls with sticks on them lying on the forest floor, would that have been used against him in trial? I think that would be a question that I should be able to ask Lieutenant Holman.
Well, I guess I understand where you're going, and again, I've already ruled on third-party suspects, and the fact that you have no evidence that connects any of those individuals to the crime. There's no DNA, we've had this discussion 1,000 times. There's no evidence that connects those folks. And whether Trooper Holman would use that evidence in a trial, he would not use that evidence in a trial, that's not his position. He stays in his lane. That's the elected official's authority to use that type of evidence, and you can't put Mr. McClelland on the stand to ask him those questions.
I could ask Lieutenant Holman if he would find that incriminating against Richard Allen.
So you want to put him on the stand, or you want to just complete your offer to prove orally?
If I can do that orally, Judge. I mean, I think, and, with all due respect, I don't agree that there's no evidence of these third-party suspects. I think there's plenty of evidence, but we've gone on.
No, you misunderstand, Mr. Baldwin. The nexus.
I believe that.
You don't have the nexus.
I believe there is more than a nexus under the law. I've not actually heard the court explain what its view of a nexus is, so I'm not really sure. I just hear the phrase, nexus. I don't know what that means to you, Judge, as the judge, but that's fine. I mean, you've made your ruling in Irie, that's fine.
Okay.
So I think I've made my record.
Anything else, then, that we need to discuss outside the presence of the jury, Mr. McClelland?
No, Your Honor, not from the state's perspective.
Okay. I'll read GHT. Then, we will be in recess until 9 a.m. tomorrow morning. Thank you.
Thank you.
Off record at 3:39 p.m. On record November 5, 2024 at 9:01 a.m.
All right. Well, good morning, ladies and gentlemen. We are back on the record in State of Indiana versus Richard Allen, 08C01-2210, MR1. I'll show that the defendant shear in person with counsel. The state shear by the prosecutor and his deputies. The jury has reassembled and is awaiting our direction. Are we ready to proceed?
We are, Judge.
Judge, I have an issue prior to bringing the jury in. We filed a motion in limine regarding Gratian's testimony today.
Yes.
And I didn't know if it will be pulled through, since the court staff was not here, so I have a copy.
Somebody printed it off for me.
Perfect. So that request is that a limiting instruction be issued regarding Dr. Gratian's testimony to admonish the witness not to testify as to opinions concerning intent, guilt, or innocence of the defendant, the truth or falsity of the allegations. Whether a witness has testified truthfully or legal conclusions, specifically the truth or falsity of the defendant's statements. I do have a case for the court's consideration. I've provided one to defense counsel as well. It is Jimerson v. State, found at 56N.E.2D117.
Thank you. What is the defense position?
Judge, thank you. Just a couple things. One, this thing just landed on my desk, obviously, this morning, although I don't think it's overly complicated. I guess I have some reservations about the timing of these things. Mr. Gratian has been on the plate of the state. They've been well aware of him for months and months, and all of a sudden now, on the doorstep of him walking into the courtroom, we get these filings. I just feel like there's a little bit of fair play that the court needs to recognize here and not put us in a tough spot in that regard. The second issue is that the requests that are in the pleading, as I understand them, are, number one, that Mr. Gratian shouldn't be able to testify about a conclusion of law. I mean, that's an evidentiary rule that the court would deal with, obviously, in the course of anyone's testimony, and you can make those decisions based on objections while that testimony's ongoing. If you're filing a motion in limine and you've done discovery of a witness and you know that the witness has an opinion and that's our bore C, then you file a motion in limine and ask for a limiting instruction because you already know what the witness is going to say. But when you don't know, it's not fair to handcuff, in this case Mr. Allen, in terms of his presentation of the evidence to the extent that he follows the rules. And then the second request is that, one witness can't testify about the truth or veracity of another witness. I mean, I acknowledge that that's generally the law. I do think one witness could testify about whether or not that witness disagrees with another witness's opinion. That's just a credibility issue to be determined by the court. So again, I think these are really just things that you would deal with in the normal course. They're not looking to limit any particular statements, and so I don't think the court should issue any instructions. I think what you should do is just wait until the testimony is offered up, and then, we would react accordingly. I think that's the appropriate way to handle it. Thank you.
Ms. Diener.
Judge, I would agree Indiana Rule of Evidence 704B has been in existence long enough for both of us to understand what it means and where it applies. The reason I'm filing this is that yesterday, when Dr. Westcott testified, there was a response to a question where she made a comparison about a principle that she was testifying about and then related it specifically to Mr. Allen with regard to the truthfulness of his statement. So I don't want to go there today with Dr. Gratian and then have to make an objection after the statement's been made and try to put the genie back in the bottle. So she was an expert. She's testified in lots of situations. I would have expected her to know better. I'd like to make sure that Dr. Gratian knows what the parameters are. I don't know if he is familiar with Indiana courts. He has a broad experience and has testified in lots of different settings, so I want to make sure there's familiarity with restrictions in Indiana with regard to expert testimony. So that was the basis for the request, and we'd ask the court to go ahead and give that limiting instruction.
And what is the limiting instruction specifically that you're asking for?
To admonish the witness not to testify as to opinions concerning intent, guilt, or innocence of the defendant, the truth or falsity of allegations, whether the witness testified truthfully, or to legal conclusions, specifically the truth or falsity of the defendant's statements.
Mr. Razi.
I think it's she's asking for a broad-based limiting statement on evidence that she doesn't even know exists at this point. Again, because there's not been any discovery done to ferret any of this out to figure out what he has to say. So I'm willing to follow the rules of the court, but I just have, the evidentiary rules, I should say. Excuse me. I'm sorry that didn't resonate well. I'm willing to follow the rules in terms of, the rules of the evidence and where the parameters are, but just to say you're handcuffing me from asking him questions about information that's not been elicited it's like putting the cart before the horse, right? I have a problem with that procedurally.
Well, I understand that and you make a valid point, but I trust that the witness has been informed what evidentiary rule 704b is. I trust that he has been told that he may not testify concerning intent, guilt or innocence, truth or falsity of allegations, whether a witness has testified truthfully, or legal conclusions.
That is correct.
He has been told that?
Yes, he has.
Okay. So as long as he's been told that and he is not going to testify about his opinion as to whether or not the testimony of another witness is truthful or untruthful, and that he's going to comply with evidentiary rules, then we shouldn't have to worry about having to put the genie back in the bottle.
Correct. And, Judge, I would just advise the court that again with Dr. Gracian, there was no report prepared, so as he indicates that the state has not made an effort to address what his actual findings are, short of taking a deposition of him there was no report to review, so we are in that circumstance.
Okay. Well, and I mean, clearly the defendant is not required to provide a specific written report, and that's the route that the defense has chosen to pursue. I see.
That's acknowledged, yes, Judge.
Okay. All right. Well, just as long as it's clear, if he steps over the line, we'll be having an argument outside the presence of the jury, and I'll have the jury excused, and we will have a much harsher conversation about what has just happened, if it happens.
As a matter of professional courtesy, I'm going to walk back out over there and tell him again what you just instructed me, even though I have told him currently 2 or 3 times that those are the parameters.
Okay. That would be great.
I will do that. I mean, I'm not looking to run afoul of any of these parameters.
And could we just have a brief sidebar about something not related to this, please?
Okay, yeah.
Sidebar conference conducted.
I know we've had issues with seating.
Affirmative response.
But the seating in the well of the courtroom, I trust that, from all the inaudible, in my position, that the only members in the well of the courtroom should be your staff members. Don't have anybody other than staff in the well of the courtroom. I know there's a woman sitting right behind Mr. Allen. I've not seen her before, I don't know who she is. Your Honor, we lost some of our seats, that is for some reason, the media's in them. That is my sister who's sitting behind us. Not in the well of the courtroom. Okay. I don't. So she'll have to move. I cannot be responsible for her safety. Okay. That's fine. She's too close to the inmate guards, she's too close to Mr. Allen. Can we have one of our seats back? The defense was allocated 10, the state was allocated 10, the media was allocated 12. Apparently, somebody took 2 of the media seats, whether it's defense or state, and it appeared that the defense had inaudible media seats. I mean, it didn't appear the media that they were given 12 seats, so I don't know, and I haven't counted. Yeah. And then, there are seats reserved for the state on the state side of the courtroom, and there are seats reserved for the defendant on your side of the courtroom, so I don't know who took things off because we're inaudible.
I'm not paid to try to figure this out.
I am not either. I'm not in charge of the seating.
Yeah, I mean,
This is inaudible.
can we just maintain the status quo until lunch, and then we'll take care of it?
Can I scoot her down? Yes, move her. Yeah. I'm sorry, that's my fault. I don't want her that close to. No, I agree. I mean, we've had some issues with Mr. Allen. I don't want to be responsible for her safety as well. That's fine. Just have her move down. Thank you.
While we're here, just to give you guys a quick update on this Lonnie Olani, sick, character, she's now moved to harassing witnesses as they leave the courtroom.
Yes.
And so she posted a video of Brad Weber leaving yesterday, where she's hollering at him and accusing him and all these different things. So this is a heads up to your witnesses. I don't know what she's capable of, but she's standing out here, and she's filming it and posting it.
She's not in the courtroom today?
I don't know. I did not look.
Is this the one with kind of the salt and pepper hair?
Well, the girl that we've had.
Yes, she's sitting right there.
Okay.
Can't we just tell her to get the hell out of here if she's going to be harassing people?
Well, she's around and she's harassing people, so I just to give everybody.
She's doing it outside.
Yeah. She's.
Public property?
Yes, from the sidewalks out here. She's not going within the barriers.
How does she know who anyone was? She's sitting right over here.
Yeah.
I've been in communication with the security detail outside and told them to, if she's being stupid and loud and she fails to comply with the directives, then that's your problem. It's outside of my hands, that's your problem. Inaudible includes exclusion from the property, inaudible. I was forwarded the video by the security detail that she has harassing.
Still better telling everybody to know what I know. So that's what I did, so I'll try to keep everybody updated.
Make up a couple new rules and get her out of here. I don't care.
Inaudible.
Yeah, I know.
Just keeping everybody updated.
So she's in here now for sure. This woman is here today, you're saying?
Is she in here?
I don't know.
Is she on that side?
I'm sorry, Judge.
I was just asking whether she was in here.
Yeah, she's here. Inaudible.
Oh yeah, I see her.
Inaudible.
And that's your mom? There's 4 of them that have just been absolutely
Inaudible.
One of them is Rick Snay, who got in a fight.
Yes.
At Fort Wayne on the courthouse grounds.
The same people?
Yeah.
It's the same, inaudible.
So just want to keep everybody aware, just, we haven't had any threats, but yeah.
Okay.
The work is hard enough with all this.
Yeah. Thank you, Judge.
Sidebar conference concluded.
All right. So, Mr. Rossi, did you wish to step outside and briefly speak with your witness before we bring the jury in?
Thank you for that. Yes, but Mr. Baldwin's calling our first witness, so?
Oh, okay.
I'm sorry, what? I'm sorry, I wasn't listening. You called me.
So are we ready to bring the jury in and?
Yes.
Okay. All right, gentlemen.
All rise.
Jury in at 9:16 a.m.
Thank you. You may be seated.
Well, good morning, ladies and gentlemen. It's nice to see you back this morning. Give you a couple of seconds there to kind of get settled back in for the morning's proceedings. I hope you had a pleasant evening. I know that you had the opportunity to access your electronic devices for purposes of contacting family and friends and for checking your work email. So to that end, ladies and gentlemen, have you read, seen, or heard any media accounts concerning this case?
All jurors respond in the negative.
Have you discussed this case with anyone?
All jurors respond in the negative.
Have you permitted anyone to discuss this case with you?
All jurors respond in the negative.
Have you conducted any research into this case?
All jurors respond in the negative.
And finally, has anybody persisted in attempting to discuss this case with you?
All jurors respond in the negative.
All right. Again, ladies and gentlemen, I appreciate your continued compliance with the court's orders. We are ready to proceed. Mr. Baldwin, you may call your next witness.
Thank you. We'd call Betsy Blair.
Witness sworn.
You may proceed.
Thank you, Judge. Good morning, Betsy.